Yeah, I don't know what to write. I don't know how. I don't. What do I say?
Call the lawyer. Call my lawyer. His name is.
Threatened to pour it on her and light her on fire. And then when the police go in there, they notice a metal gas can sitting on the floor like the one that she described. What you don't get to do is show outward, expressive disrespect. As a licensed attorney, you're an officer of the court.
I apologize, Your Honor.
There won't be a third. It'll be contempt.
Those clips you just watched weren't just a husband asking for a simple favor. It was a convicted felon caught red-handed. But what the judge discovered about that positive letter and the metal gas can found on the bedroom floor, that's where the true horror of this case begins. This is Lawrence Goddard versus the people. It starts with illegal gun possession, but the reality is chilling. Prosecutors say Goddard beat his wife and threatened to burn her alive. Goddard's defense? It's a mess of contradictions, shifting from claims of BDSM sessions to a suicide attempt. While behind bars, he was caught on tape coaching his victim to lie for him to shave time off his sentence. Was this a man seeking God or a predator seeking an exit? If you want to understand courtroom psychology and how judges spot a lie, hit subscribe. Let's head inside the courtroom for the final sentencing.
Brings us to our last day. People will be Lawrence Goddard, file 25-93374 FH for sentencing and contempt hearing. Counsel, you want to state your appearances, please? Beginning with the people.
Jeremiah Buffalo, work on behalf of the people.
Good afternoon, Your Honor. Christopher Price, P84943 on behalf of Mr. Goddard, who is seated to my right.
Okay, good afternoon, and we're here for sentencing, and also we've adjourned it a couple times, and most recently then so that we could give the prosecutor an opportunity to go forward with a contempt allegation. Mr. Virgo, ready to proceed on that?
I believe so, Your Honor. We have some audio to play. We're getting a little hiccup with our IT. Of course, our machine. This thing takes forever to load, Your Honor. So I've got my flash drive, but I have no means to play it. We're in an IT hole right now, and we literally don't have a laptop that is functioning right now.
But it's warming up right now as we're speaking.
We're dealing with laptops that are older than me in some situations. It seems it can literally take 10 to 15 minutes for them.
Mr. Parks, you've been provided with a copy of this?
I have, Your Honor.
So your proofs are going to consist of an audio of a phone call from the judge?
3 separate calls. We pared it down to, Your Honor, though I would indicate that those 3 calls together are around 34 minutes in total length.
And you, Mr. Parks, do you have any objection to the court's receiving and considering those?
I do not, Your Honor. The only objection I have is the context from whatever audio Mr. Virgo was playing, in which case I would like to call my client to clarify any issues.
Then, so that we have a good record, you're gonna mark that as an exhibit and we can have that in the court file.
Yes, Your Honor. The thumb drive is the court's.
And that'll be marked then as People's Exhibit 1. You have no objection to the admission and publication for the court of Exhibit 1?
I have not, Your Honor. I also have a, depending on what audio people play, I also have some audio to play from. It would be the same jail calls, Your Honor, just perhaps different calls that were made, so.
And if I may, Your Honor, for the record, this would consist of 3 phone calls. One of those calls being from November 5th of 2025 at 8:35 p.m. The other being on 11/17/25 at 11:13 a.m. and the third one being 11/23/25 at 10:02 a.m.
What was the last one?
Last one was 11/23/25 at 10:02 a.m. And I did not, I didn't shorten them or reduce them. Those are the calls in full as we got from the jail. I would note, I do believe, Your Honor, that there is a stipulation as to the authenticity and foundation of those.
And you both believe that I need to hear all 34 minutes. There's not excerpts that you want to queue up and direct my attention to, or?
Your Honor, from the defense's perspective, he's not denying that he had contact with his wife. You're going to hear his voice and her voice on there. The issue is the context that the people are trying to present, that he's trying to convince her to do these things. And if the court's inclined to hear the entire video or entire audio, then yes, absolutely, my client should be able to at least explain himself as to that. And the context is what's going to matter, unless the court wants to just rule that he had contact with her, and that in itself is a violation, which if that's the case, we have no objection, Your Honor. The people have already said they're not going forward with any future felony charges based off of the phone calls. So I'm not entirely sure what all what the end game is when he's already admitting that he's had contact.
So, Mr. Virgo, if the yes, is it relevant for me to hear all of those then?
I believe so, Your Honor. There is an implied tit for tat. There is offers of a vehicle and providing a vehicle, along with inducing to write a letter for this court. That is the onus, and I do believe that that would potentially form grounds for this court to deviate upward from the sentence guidelines.
Or if the facts come in as you've alleged, I suppose that could support a score under OB 19 for attempting to interfere with the administrative justice.
I believe it would as well.
All right, and Mr. Parks, violating the no contact provision alone would not warrant scoring OB 19, correct?
Correct, Your Honor. It would give the court the ability to give contempt for Mr. Goddard for violating this.
And so the prosecutor said they wanted to have this hearing to inform the court's sentencing decisions, and that could involve OB 19 as well. If there's some attempt to influence testimony or something, or discourage testimony, that would be scoreable under OB 19. So I think I guess we do need to hear them. So okay. So are we ready to play now?
Connected. This call is being recorded and has a maximum call length of 30 minutes.
Hey,
Hello?
hey,
So before we play that, I am providing enhanced public access through the live stream. Before we start playing this, are there parts in this that are of a nature that we shouldn't be doing so?
Curse words, Your Honor, but
Okay.
that's
Nothing that would cause any difficulty for a complaining witness, or?
I don't believe so, Your Honor. I
Okay.
believe the complaining witness has been present in the court on numerous occasions.
Okay, would you agree with that, Mr. Parks?
I would, Your Honor. I don't see the complaining witness in the courtroom.
But I mean, there's no portion of this conversation that's of such a private nature that we should
I don't
end the
believe.
live stream.
I don't believe so, Your Honor.
I don't think so, Your Honor, but if we could approach, just in case it is, I'd like to tell the court on a sidebar real quick.
Okay. Approach this spot. right, and after conferring with counsel, I don't see any reason why we can't go ahead and continue. I'm not sure if your shared screen might have ended. So. You unplug it and put it back in. So. I'll hold it for a second. Something has your power panel. Okay, try again.
Call is being recorded and has a maximum call length of 30 minutes.
Hey,
Hello?
hey,
How you doing?
I'm all right. How are you?
All right.
No, not really.
No?
No, I was talking to somebody else. He asked me if I was watching something on TV.
Oh.
How are you?
Ow. Fine.
Yeah. Good. Get a hold of
Hey, I
mom.
tried to talk to Marie yesterday. She don't
Yeah.
want nothing to do with me.
Why?
She told me to change my address.
Why?
What do you mean why? I don't know why. That's how she's been.
Huh. Well, I'll try talking to her later. I tried to call, she wouldn't answer for me.
No, Sandy said you're not going back there.
Huh?
Sandy said you're not going back there.
Oh yeah? Who said that?
Sandy.
Sandy's not the one. Mom already told me I could go back there. I don't understand where Sandy's getting her information from.
I don't know.
I'm not going to cause a pissing argument from it anyways.
Right?
No, I'll buy the motorhome. Just got to put fucking gas in it.
Yeah.
Yeah, you can go stay there if you need to. Are you okay?
Yeah, I'm all right.
No. Are you okay?
I'm okay.
Okay.
Probably gonna go stay in Gaylord. That's where all the jobs are.
No. When I get done, we'll talk about all this. And don't shut me down. I'm just making a statement. Things would be different.
I gotta do what I gotta do. I gotta live.
I'm telling you right now, go to your mom's.
Well, I'm telling you, I went over there yesterday and she gave me my mail and told me to change my fucking address.
Really?
Yes.
Wow. You went over there?
Yeah.
Okay. I will call her when I'm done talking to you.
I picked up the truck.
Huh?
I picked up the truck.
Oh, you have it?
Yeah. We took the tools and stuff out of it. Sandy did. You there?
Yeah, I'm here. I'm listening.
You keep breaking up.
No, I'm not breaking up. It's you're breaking up.
Well, I don't have a problem unless I'm talking to you, so it's not me.
Oh, it's this phone here then. Oh, don't lose my truck.
Not gonna.
And don't Hey, I need you, when it's time for me to get out, you need to be somewhere where I can be picked up.
I know.
Don't fuck me around. Don't have insurance and the plates aren't legal.
I'm gonna transfer the insurance and plates from the car onto it.
Are you?
Yeah. We'll do that tomorrow.
Oh, yeah? Okay.
I'm gonna try to. I don't know it's not my name, but I'm gonna try to.
Well, if you need to have me sign something, I can sign it, whatever.
I think I should be able to because I'm your wife. I don't know.
Should be able to. Well, you shouldn't say that either.
Right. Sorry.
No, it's not your time, it's mine. Just more of it, it don't matter. All right, I gotta go. We'll talk to you. Have a
Are you
good night.
fucking serious?
No, I'm not serious. Why would I be serious?
All right, Larry. You have a good night.
I'm trying to talk to you, and you gotta watch, you know. Come on.
All right.
So have you considered the letter?
Yeah, I don't know what to write. I don't know how. And what do I say?
Call the lawyer. Call my lawyer. His name is Chris Parks. Here, I'll give you a number.
So how did you message me on WhatsApp?
Don't worry about that. I got
I'm
lucky.
looking for a pen. All right, go ahead.
989
Yeah.
358 2100.
All right.
And his name is Chris Parks.
Chris Park.
Yep.
All right.
Just ask for him. Tell him you need to talk to him. And when he talks to you, ask him what you need to put in there.
All right.
So anyways, all right. I'm gonna call Mom.
All right.
Behave yourself.
All right. You too.
What am I gonna do?
Well, I don't know. I almost got in trouble in there.
I ain't getting in no trouble. Ain't nobody fucking with me. I actually made some friends.
Good.
Yeah, gonna have to have somebody when I get out of here.
Okay.
I love you. I hope you have a good night. We'll talk to you. I'll call you in a couple of days.
All right.
Sometimes I might just ring you, let you know I'm thinking about you. Okay?
Okay.
Did you write down that thing, that CID?
Yeah, it's like $91 a month.
$91? No, there ain't no way.
Yeah, it is. It's like $2,000 a year.
CIDOS?
SIDOS at .net.
CIDOS. Not
CIDOS.
CIDOS.
All right.
You got a pencil in your hand.
Okay.
Yeah, it shouldn't be no fucking $2,000 a year. I should be able to pay for it here and get a hold of you there. All right.
CIDOS.
CIDOS. It's a capital OS. Capital O and S are capitals. O and S are capitals. All right. All right. Talk to you later. Have a good night. I love you.
All right.
Okay. Thanks.
I love you too, Larry.
All right. Bye.
Bye.
Okay, and then we can do call 2 on November 17th.
This call is being recorded and has a maximum call length of 30 minutes.
Hi,
Well,
how are you?
all right.
Are you? Good. What's going on with you?
Eating nachos.
Yeah,
Homemade nachos.
good. Sounds good.
Basically Doritos and cheese with some olives.
Yeah. Well, I'm glad you're eating. Glad you got what you need. I hope you got what you need anyways. You talked to my lawyer yet?
No.
You need to talk to him about what do you need to write in that letter for me, please? I'm not trying to push you. I'm not trying to, how do I put it? Influence you either way. You need to write a letter for me if you could. Something positive that would help. If you could do that for me, I would appreciate it. All right.
How are you?
Huh?
How are you?
I'm fine. I'm gonna be okay.
Tyler come visit you yesterday?
Huh?
Tyler come visit you yesterday?
Yeah, Tyler, come and see me. Brought me a thermal shirt, so when I go outside, it's not so cold. He was supposed to bring me some pictures. He asked Mom to print them off, but of course they didn't get that done for him. So I doubt if I'll get them. But that's all right. It is what it is. But the reason I'm asking you to do that sooner is I'm gonna push for my lawyer to get me sentenced on the 1st. So I can be eligible for Sheriff Good Days and anything, they have work days that they can do where they take guys out of here and you can go get a day for a day, you know. Maybe I can get out a few days early and not have to spend the complete holidays in here. If you understand what I mean, every day is one day closer.
Right.
No, I'm just trying to get my shit done so I can get out and go back to work. Start doing my probation. That's all I want. It's dead time. It's basic dead time right now. So I'm in my Bible, praying, studying, trying to get my head together where I need to be, what I got to do and who I got to be when I get out. You know what today is, don't you? Did you hear me?
Yeah, I heard you.
You know what today is, don't you? 10 years ago today, Dad passed away. We were on our way into Rogers City. He died away. We got that phone call.
Don't do that to yourself.
Yeah. I've done this to myself for days, months. I've been beating myself up bad. I regret a lot of things. I have a lot of regret. I'm trying to forgive myself for everything I've caused everybody. I see it. I'm going to change and be different. I'll be a different person when I get out. Hopefully you can benefit from that instead of it being the way that it was. Even if it means I gotta leave you alone, then I guess I leave you alone. I would prefer to give you 20 years of good time instead of 10 years of bad, like a, I don't know. It's out of my control. I give it all to God. He's gonna be the only one that decides what happens with me in my life. You know who I am. I see what I've done. I see what I've caused. And I know how to fix it. Not for you, not for them, for me. Because I deserve to be a better person and you guys deserve a better person. That's simple. You deserve a better husband. You deserve a better man. And you deserve a better friend than what I had been to you. And I can be that person. And I know it. I am going to be that person. Well, I won't bother you. I left you alone all weekend intentionally. I'll try to give you a few more days before I call you back again. You sort your own stuff out in your own head. My cigarette's still in the truck, I hope.
Yeah,
When I get out, I still gonna have cigarettes?
yeah,
Are yours still, you took yours, right?
yeah.
Okay. Well, if there's any way that I can get you some money while I'm in here, I will try to get you some money, okay?
You need your money for you.
Huh?
You need your money for you.
No, I'm fine. I got everything I need. It's my job to take care of you. You're still my wife. If I can help you, I will help you. It's that simple. That's my job. And if I'd have done my job correctly, I wouldn't be where I'm at now. And I know that. Okay?
You're not there because you didn't give me money.
Huh? Do what?
You're not there because you didn't give me money.
I understand that, Doc. That's not what my self-worth comes from providing for my family, or it did. Not no more. But that's where it did come from. I've spent a lot of time analyzing who I am, why I did a lot of things, the things that I had been through. And when I get out, I would love to sit down and have dinner with you and talk about, just spend days. I'm going to buy Mom's motorhome. I think, I don't know. I hope I'm going to buy Mom's motorhome and I'm going to go and just exist for a little bit and take a little trip and just drive around. We'll be the gypsies. Something that we'd always dreamed about doing. I'm not talking leaving state or doing any of that because I can't, but I can drift from area to area and just kind of exist. And it don't have to be to get high or any of that kind of thing. Just to be. Enjoy life the way it's supposed to be enjoyed. Food, friendship, love. A lot of things going on in my head. And I would like to discuss them with you. Really, really would. Unfortunately, I had spent so much time worried about just getting us high and doing those things that we missed life. I missed life.
Yes, you did.
No, I don't want to miss that no more. Because you were right. And I was wrong. I see it. But anyways, lunch is going to be here in about 5-10 minutes.
This is good food.
I'm not eating today. I'm fasting. Praying. Trying to cut some weight. Trying to get rid of the jiggle in my belly. We're working out every day. Every day. No more stomach in the way. So when whoever puts their head in my lap, they don't have to put it on my fat belly. They can actually just put it in my lap.
Larry,
What? Tone. Ready. Ready for the physical things that I need to be able to do. And I'm sure you can read into that. We were two physical beings that really enjoyed each other's company. We did sit-ups, and push-ups, and sit-ups, and push-ups, and sit-ups, and push-ups, and tone. Now I'm trying to cut 15, 20 pounds. That don't matter. The physical attributes doesn't matter. It's the mental aspects of all of it that really matter. So anyways, thank you for taking my call. Thank you for talking to me. Thank you for listening. I hope you hear and understand me.
Not crying.
It's been constant since I've been here. About everything. Mr. Mrs. You. Your Mr. Mrs. is a little one. I miss my wife. I miss my friend. I miss myself. But I found him. I found him. You'll see him when he gets out. If you let me come and see you, or come and see me, however it works. I'll be who you need me to be. I guarantee you. I'm not going to swear on God or any of that kind of thing. I'll promise you I will be who I'm supposed to be for you. I will make up for the last 10 years. Given the chance, I will make up for it. Treat you like the queen you're supposed to be. All right, I gotta go. I love you. I love you. I love you. I love you. I hope you have a good day.
Bye.
Bye.
Third call, this would be November 23rd.
Your Honor, just for a clarification, there are, at least I've received 5 calls from November 23rd.
This is the one at 10:02 a.m.
This call is being recorded and has a maximum call length of 30 minutes.
Morning.
Well,
Hi. How are you?
all right.
Yeah. What's going on with you?
Nothing. Covering at the moment.
Yeah. That's funny. That's what I've been doing too.
Yeah.
Yeah, I colored you some pictures.
Did you?
Yeah.
Ouch. Oh, my leg went numb.
Yeah,
Mm,
sorry.
Not your fault.
I know. Still sorry. See, I colored you a few pictures. Thinking back to simpler days.
Yep, things were a lot different.
Huh?
The things were a lot different.
Yeah, I know they were. Simpler days. So just reflecting. For sure.
It's not like I couldn't see the writing on the wall. We were pretty hostile.
I'm sorry.
It's not like I should have seen the writing on the wall. We were pretty hostile.
Well, it don't have to be that way. It don't have to continue that way. That's for sure. Either way. Either way. All right. Well, I just wanted to call and say hello. Let you know I was thinking about you. Hope you're okay. Hope you made an appointment, got yourself some new glasses.
I did.
Good.
They're 20% off.
Yeah?
Yeah.
20% off.
Yeah, that's the insurance.
Okay. So how much were you able to actually get them?
I haven't got them yet. They're $100. That's without
Okay.
transitions.
Really? Blue
Yep.
Cross Blue Shield?
Yep.
Really? So somehow.
It's not your old insurance.
Huh?
It's not your old insurance.
It's not my work insurance?
Nope.
Huh. That'll make no sense. Really don't make no sense. When I get out, I'll get it figured out. I should have work insurance.
That's
But anyway.
$100 without an exam or anything.
All right. Well, I'll see if I can get somebody to give you $100. You can get your folks glasses. Okay?
I'll get them. I will start work tomorrow.
Huh?
I'll
thought
get
you
them
already
and start work. Well, I went to training.
Huh?
I went to training.
Oh, okay. Well, I'm not sure what you're doing. You're not said anything. We've not really talked, and I've been avoiding any of that. Trying not to pressure you, letting you be who you are, and I'll be who I am. And let's see where we can go from there. I'm still your friend.
Well, you know my opinion on that.
Yeah. Well, your opinions change, and I can prove differently. Okay? Don't hold that. Please, just give me a chance here.
Haven't I done that before?
Okay, let's get stuck there too.
Not being stuck, really.
Okay, then don't. Don't. It's your choice. Okay?
I just know I've done this before.
No, we haven't. I've never been where I'm at now. Have I?
No, somehow no.
No, I've not been where I'm at now. And if you don't think this has changed me and I've seen and had a chance to really reflect, I have. Did you get my message? My mom died?
Yeah, I asked Tyler, and he said not that he knows of.
No, Carmen passed away. My mother that raised me from the age of 5.
That's how Becky raised you for years and years.
Becky wasn't until we were teenagers. I didn't meet Becky until I was 13. Carmen was my sister's mother, who I had in my life until she was killed. So anyways, my lawyer's trying to get my sentencing date moved forward.
Yeah.
To the 1st. Yeah. We're just waiting. Hopefully the PSI pre-sentence investigation is completed and given. If that's done, then the sentencing can be moved forward. So I'm not sitting here on dead time.
Right.
Sheriff Good Days. I actually get an out date and all that kind of stuff. So maybe I can, I don't know. We'll see what happens. It's all on the judge. But like Chris or Mr. Parks told you, what you have to say will definitely influence what happens to me. So I guess if you want to see me sit for longer and you feel like punishing me more, then you can. Well, that's
I haven't punished you at all.
Okay. If you don't think me sitting here not wanting to being able to talk to you is not a punishment, you are my. I guess it's me punishing myself then for what I did. How's that? Regret and all the other things that I've been going through in my own head. All right. Well, I won't bother you. I'll call you sometime, maybe next week or next month or whenever. I hope you have a good day. And I love you. Talk to you later. Bye.
Bye. Bye.
All right, any additional proofs from people?
No, Your Honor.
Okay, as to the contempt question, any additional proofs from the defense?
No, Your Honor.
Okay, argument on the contempt, Mr.
Not much argument. He wasn't supposed to talk to her. Clearly he did.
Okay, on the contempt question, Mr. Parks?
No,
Like you didn't contest that there was the contact.
there's no contest that there was contact, Your Honor.
Okay, well, I guess based upon that, I'll issue a judgment of contempt and find Mr. Goddard in contempt of court. The show cause looks like was signed on December 15th by me. So from that date till now, he's got more than 93 days credit on that. So I'll give him, we'll enter a judgment of contempt, 93 days jail credit for 93 days served. Okay, so then we can move into the sentencing. Mr. Parks, have you had a chance to review the pre-sentence report and information with your client?
I have, Your Honor, and I also did receive back on January 27th an updated jail credit.
Yeah, it looks like if I were to calculate through to today, I'm getting 149 days.
I've got 155, Your Honor,
155.
because there was 98 as of what would have been the first or the next hearing, which was. Apologies, Your Honor, I'm pulling up my calendar.
Got 65 as of January 5th, and then I added another 84 from January 5th to today. Agent Lesky, did you recalculate?
I have 154, Your Honor.
154, okay.
The 155 if you were including today.
I was including today, I'm sorry.
Okay,
Yeah,
and the
so
DOC doesn't count the sentencing date because that counts as a day he's serving the sentence.
Correct.
Okay. Then I have 154, Your Honor, from the last date that we received an update.
Okay, great. 154, any objection to that date, Mr. Virgo?
They're gonna count them better than I am, Your Honor.
Okay. All right, so we got 154 days credit. Other than that, no additions, corrections. Any additions, corrections from the people?
Yes, Your Honor. Well, no additions or corrections, but objections, Your Honor.
So as to the scoring, it's at 0 to 11 months. Any challenges to the guideline scoring, Mr. Park?
Not from me, Your Honor.
Okay, and Mr. Virgo, any scoring challenges from the people?
The people would give scoring challenges to OBs 1, 3, and 19. Would you like me to go all at once or take them piecemeal?
Let's do one at a time. So as to OV1, that scored at 0 points. Go ahead with.
Your Honor, the people believe that OB1 should be scored at 20 points for exposure to an incendiary device. In the incident narrative, the description on page 2, it would be the description of narrative section 1, 2, 3, 4th paragraph down. We indicate that the victim indicated that she was held at gunpoint and there was a can of gasoline that was brought into the residence, threatened to pour it on her, light her on fire. If that weren't the case, Your Honor, then we would also get 50 points for a firearm pointed at her. There was a firearm pointed relative to any McGraw issues. Your Honor, defendant was in possession of this firearm the entire time. McGraw tells us that while it is OB1 is an offense specific, it is any conduct that happens during the commission of the crime. Defendant had this rifle the entire time. People v. Chlemicki examined where during a unlawful imprisonment claim, the defendant had brought a victim into the apartment and pointed a BB gun to her head. Because she was still unlawfully imprisoned and couldn't leave at that point, it was upheld that scoring for the pointing of the gun to the head, though it wasn't a firearm in that case, was appropriate. I do believe that it would be appropriate to score this for the incendiary device again at 20 points here.
Okay, so Mr. Parks, the prosecutor is saying that OV1 should be scored at either 20 points. Well, I mean, I'm going to dismiss that out of hand. The 20 points I don't see because even accepting the information PSI that he brings in the gas can and threatens to set her on fire, she wasn't subjected or exposed to an incendiary device. As I read that, so I wouldn't sustain the objection for the 20 points.
Okay.
But as the prosecutor says that we should score at least 15 points for a firearm being pointed at or toward a victim, or the victim had a reasonable apprehension of an immediate. Okay, I'm sorry. A firearm was pointed at or toward a victim. What's your response as to?
Your Honor, I would object to the I think the scoring is appropriate at 0. And the reason I state that is, Your Honor, there was never testimony from the victim in this matter. We have a police report that would be hearsay evidence just on its own, Your Honor. She never contacted anybody from probation to corroborate the story. At this point, it is a uncorroborated statement made by the victim in this matter, and the victim's not even here to even give a statement to corroborate what she stated. If that were the case, we would have to believe everything that's in a police report that's ever written. And Your Honor, I don't think in this scenario there's any actual evidence that the gun was pointed at her. Even the night where Mr. Goddard is at the home, the first incident, they never find a weapon at the home. It's not until they get an anonymous tip from Mr. Goddard's stepkids who are at the home while Mr. Goddard's not even been there for 5 days that they say, oh, while we were searching the laundry room, we found a weapon. And then the police are able to go in and get the weapon at that point, even though it's not been proven that the weapon was even there at the house during that incident.
Well, his description of the offense was, I was attempting suicide and my wife stopped me.
Well, then that would be on him, not on her. There's no proof that he pointed the gun at her.
You just said there's nothing to indicate the gun was present, but his own statement
was
the gun present.
In regards to her, then, Your Honor, there's no statement to say that he pointed the gun at her. Clearly his statements wouldn't be hearsay as he's explaining his events of that night. I don't think you can score anything. I mean, maybe 5 points on OB1 if the court is going to grant some change to it, as the weapon would be displayed against himself. So if the court's willing to go that far, I think 5 points would be the more appropriate if the court's not going to go with 0, as we don't have any definitive proof that the weapon was ever actually pointed at her.
All right, well, to clarify my earlier remarks, that the statute does define gasoline to be an incendiary device. I'm just finding that the victim was not subjected to or exposed to it. Perhaps if there had been some kind of attempt to splash it upon her or something, I would certainly do that, but I'm not sure the mere presence of the gasoline can would constitute subjecting or exposing her to the substance.
If I may, Your
To the
Honor.
device, yeah.
I would just argue that exposure is the threat of it, because along, there are also explosive devices. We don't, it would seem that the legislature wouldn't have wanted the actual exposure where the bomb doesn't have to go off, if you will, or the dynamite doesn't have to be touching the victim. If they think that they could be blown up or lit on fire, which with a can of gas in the room could happen, I do think it would be exposure, Your Honor. Thank you.
Your Honor, and under People v. Ball, actually, the Supreme Court says that, or sorry, the Court of Appeals actually states that OV1 is the actual use of that weapon. And People v. Ball, there's a incident where somebody died from a heroin overdose in this scenario, Your Honor, and the Supreme Court said, yeah, use of that heroin does not constitute a harmful chemical substance, because they're nonetheless lethal doses, as this case demonstrates, is capable of causing deaths and therefore a harmful chemical substance. Nothing in MCL 750-200 HI restricts the definition of harmful chemical substances to those substances that are lethal all at dose levels. We do, however, agree with the defendant that it was not, under the facts of the case, used as a weapon. So even in that case where they're saying that heroin was the reason for the person dying, it wasn't used as the specific weapon in that scenario. So by that definition, Your Honor, I don't think you can score 20 points for OV1. I would agree 5 would probably be the maximum that you could score on it, as Mr. Goddard stated that he was going to kill himself, but I don't think that there's ample evidence to show that he ever actually pointed the gun at her.
All right, well, now I have heard argument from both sides on that. At first, I dismissed the prosecutor's contention as to the 20 points out of hand. But then after that, I see the statutory definition: incendiary device includes gasoline or any other flammable substance, a blowtorch, firebomb, Molotov cocktail, or other similar device. So clearly that doesn't require that it actually be detonated, just that has to be present. You're exposing the victim to that incendiary device, similar to pointing a firearm at somebody. It doesn't say you shot them. This is saying, you get 25 points if the firearm's discharged, but just pointing it is 15 points. So, I think 20 points, the victim is subjected or exposed to an incendiary device. Was this victim subjected or exposed to gasoline? And she says he held her at gunpoint. He brought a can of gasoline inside their residence. He threatened to pour it on her and light her on fire. And then when the police go in there, they notice a metal gas can sitting on the floor like the one that she described. I think after hearing arguments from both counsel on that, I do find a preponderance of the evidence that the victim was exposed to the incendiary device of gasoline. OV1 20 points. I would indicate for the record that I also give credence to the 15 points for a firearm being pointed at or toward a victim. That was what she had described in the uncontested portion of the PSI. And then the defendant just denied that there was any gun there at all. Then later the gun is found. And then in his description of the offense, you can infer from the statement that he admits the gun was present.
Your Honor, may I?
Statement is, well, I heard argument from both sides and I'm making my ruling, right? So you can shake your head all you want, but that's how it proceeds. I hear from one side, I hear from the other, I make my ruling. It's not a debate.
Yes, Your Honor.
All right, so if I didn't score it at 20 points, I would certainly score it at 15, but I'll score it at 20 points. All right, Mr. Wirgo, as to OV3.
As to OV3, Your Honor, I do believe it should be scored at 5 because of an injury not requiring medical treatment. That same paragraph I referenced for OV1, she does indicate that he punched her all over and she did have bruises. She did not seek medical attention, and I would concede that just the bruising doesn't require medical attention.
All right, Mr. Parks, your response?
Your Honor, my client also stated that those bruises were from a BDSM session they had. They have a signed contract that showed that they did that, and those bruises are not from that night. They are from a previous session. So to conclude that that is where the bruises come from, again, I believe is inappropriate at this point, Your Honor. And I still believe that it's appropriately scored at 0.
They pled to domestic assault, right?
But that's not what the sentencing offense is at this point, Your Honor, for the PSI. That would be the felon in possession of a firearm.
What's the factual basis for the domestic violence?
Your Honor took the factual basis and said that having the firearm and pointing it at her was enough for the domestic violence. Put her in the apprehension of harm, or apprehension that harm was going to occur to her.
Well, I mean, that alone would have supported the 15 points then, if he pled to a charge that the factual basis included he pointed a firearm at her, wouldn't it?
That I would agree with, that I conceded 15 or 5, Your Honor, but
Well, you never conceded 15. Did you? I didn't hear you concede 15.
I said it could be 5 or 15, Your Honor. I was arguing more for 5.
Okay. Mr. Virgo, rebuttal argument.
No, Your Honor, just on my original argument.
Well, I mean, in the possessing of this firearm, it's in the context of right, the victim reported that defendant had punched her all over, and she showed the officer bruises on both sides of her body. That happened while, in the course of this offense of possessing the firearm, pointing it at her, threatening to shoot her, threatening to pour the gasoline on her and set her on fire, and punching her. The defendant gives an alternative explanation for the bruises, but that doesn't negate the ability to find that he's pled to the possession of the firearm and also domestic assault under those circumstances where the victim did suffer physical bruising. I would score OV3, physical injury to the victim, at 5 points. Mr. Virgo?
As to OV19, I have a 2-pronged argument, Your Honor. One being that the testimony that the audio that we heard shows an interference with the administration of justice. We don't have it in an absolute contractual nature. I offer you this in exchange for this, but we have promises of a future life. He'll be better providing a truck. I'll get you that $100. And then we have go write the letter. This will change my time. I think that is interfering with the administration of justice. He's trying to influence a witness for the PSI. He even specifically references the timing of the PSI and how it will influence that. Also, Your Honor, on a separate and distinct argument, when interviewed, the defendant swore up and down there was no gun. He never touched it, but yet he went ahead and then pled to possession. So I believe that would potentially rise to the level of mere just denial that we would normally see, and would be an active attempt to influence the officer's investigation.
All right, Mr. Parks, as to OV19, your response?
Your Honor, it's appropriate scored at 0. You never heard anything on any of the recording saying, if you do this, I will do this for you. You have a husband who's asking his wife for a second chance. He's telling her that he's a changed man. He's being better. He's completely changed for the better. He's never offering to do anything for her in any kind of exchange for a quid pro quo or anything like that. He's saying that he's got insurance. He's helping her get her glasses because he's still obligated to, as her husband, to pay for her glasses in that scenario. He's not saying that you can't have the truck. He actually is saying, I'm going to give you money to help with the truck, as she just started a new job. She even said that on one of the audios.
Yeah,
She was
I don't
heading to her.
hear a connection on a quid pro quo by preponderance, but I am wondering about would it be attempting to interfere with the administration of justice, asking the complaining witness to write a letter of support, in particular in the third call when he says, you know, what you have to say is going to influence what happens to me. If you want to see me punished more, then don't do this.
Your Honor,
Kind of laying on a guilt trip to write something to help her.
and those are just straight facts. She could have called the victim advocate, and the victim advocate would have said the same thing to her on the phone. Just writing a letter is going to either influence you one way or the other, or it's not, depending on how the letter is written. He's not saying, I want you to write all these good things about me. In the second video, he even says, I'm not trying to sway you one way or the other. If you think I should be in here, then I should be. He's not telling her, say these things so I can get out of here. He's not interfering with her at all. He's saying, if you would, you can. She has that right as the victim anyway.
Right. Well, she would have the right to recant as the victim, but if a defendant is contacting her pre-plea, for example, and saying, I want you to go write a statement that this didn't happen, that would surely be scored, right?
That would be completely different than what we're asking for today, though, Your Honor.
But so just the fact that the victim could contact the victim advocate, you know, here, but that's not how it happened. It's the defendant contacting her and saying, you know, he does say, I'm not trying to push you or influence you either way, but then he says, just write a letter for me, something positive. So it seems like he's trying to influence a victim impact statement. That seems pretty clear. He's trying to influence a victim impact statement. So
He's not doing it to his benefit or his detriment, Your Honor. He's telling her one way or the other.
But
So I don't
if you
see
want
how
to say,
that's.
just write a letter, something positive.
He also says you can go one way or the other, Your Honor. So he's giving her the option. He's not telling her specifically, write this for my benefit. He's telling her, if you think that I deserve to be in here longer, tell them that.
If you want to see me punished, so I think
Exactly.
which I think that the totality of those circumstances, that I do find that he's trying to influence a victim impact statement to make it positive. I think that's pretty clear. And just him saying, you know, making a statement, I'm not trying to influence her one way or another, is that doesn't insulate him from all the other stuff he says. You know, I go to a delicate, you don't have to keep
I'm not,
everything you
Your Honor.
disagree that I say. This seems to be a constant issue with you, Mr. Park. It's okay to disagree with the court and with the judge, and I might be wrong. What you don't get to do is show outward expressive disrespect. As a licensed attorney, you're an officer of the court.
I apologize, Your Honor.
All right. I expect I don't have to correct that again. This is the second time I've told you that in your practice in front of me. There won't be a third. It'll be contempt. You know, if I walk into a delicatessen and say, nice story you have here, I'm not going to do anything to hurt it, but it'd sure be a shame if something happened here if you didn't, you know, do this or that. You know, me saying I'm not going to do something doesn't insulate all the other statements. So I think that there's clearly evidence here that he is trying to influence a victim impact statement. My question to you is, as a matter of law, would that be interfering with the administration of justice? Because he's not trying to get a victim to say recant. He's just asking for something positive at the sentencing. And does that fit the parameters of OB-19?
In my opinion, it does not, Your Honor.
Okay, Mr. Wirgo, why would they, if I'm not finding sufficient support for your quid pro quo theory, but I do find, based on the calls I heard, that the defendant, in violation of a court order, was contacting the victim and doing so in a way seeking to influence the victim's victim impact statement to his benefit. Would that support a score for OB-19 or not?
I believe it does, Your Honor. I gave a quick 15-minute look for case law directly on point, could not find any. I think that sentencing is where the justice happens, Your Honor. Adjudication is just one point of it. Pre-trial issues is just one part of justice. When we look at theories of punishments, they're rooted in justice, so many of them. maybe not so much, the rehabilitation prong, but deterrence and the community, if you will, bloodlust. I can't remember the proper term for that, but Your Honor, justice is the sentencing. So I believe that in that aspect it would. And then if the court disagrees, again, Your Honor, I would ask you, and even if the court does agree, for a ruling on the issue of the lying to the officer relative to never having possessed.
So, Mr. Parks, I haven't heard your position then on the alternative scoring for OB-19 at 10 points for the defendant lying to the police about the gun being present. Would that support a score of OB-19 or why not?
I don't think it would, Your Honor. I mean, just because you tell the officer, there isn't one. People tell officers all the time, nope, I've not been drinking. I don't have any open containers of alcohol in the car, and then lo and behold, they find one, and they're not getting scored for interfering with the administration of justice, Your Honor. I think it's a stretch to say that lying during the investigation or not being fully truthful about it would constitute that. Clearly, there's a charge that the prosecution could have charged him for with that, and they dismissed it. So that's
right, but that doesn't mean that we don't get to consider that for sentencing purposes.
And it was considered, Your Honor, because that's why he got 10 points on OB-10 for contemporaneous felonies that weren't adjudicated. He got 10 points for at least three for at least three other charges that he could have been charged with. So I think that satisfies where the other 10 points should come from OB-19.
Okay, OB-19 is for interfering or attempting to interfere with the administration of justice. The prosecutor contends that should be scored at 10 points for two reasons. I agree with both those reasons. First, the defendant, based upon the phone calls that we've heard, is in violation of a court order of no contact with a victim of an assaultive crime, is contacting that victim and seeking to influence her statements to a court at sentencing. He didn't succeed in that, but he did attempt to do that. And that does interfere with the administration of justice, which does include what's the proper sentence to be given. And in my determination of that, I'm supposed to consider any statements that the victim makes. So any attempt to inject corruption into that process would support a scoring of 10 points. Alternatively and equally, I would score OB-19 at 10 points for lying to the police officers about the firearm. The case law does support lying to the police to be at 10 points under OB-19. It has to be something beyond just a denial of the crime. I'm innocent. The defendant is allowed to protest his innocence, even deceitfully, without, or even he can protest his innocence even when he's guilty without scoring OB-19. But here are the specific statements about the gun, and it is found, and it's found, with the hammer cocked and one around is chambered. The way the hammer was in a cocked position, the action is closed, and there's a live cartridge that's chambered. So for both those reasons, I would sustain that objection. I'd score OB-19 at 10 points. All right, so that adds 35 points. That would bring the total OV to 45 points instead of 10 points. And on the E grid, that would put us at OV level 4 rather than OV level 2. At C4, he's at 5 to 23 months. Is that right, Mr. Virgo?
It is, Your Honor.
Mr. Parks, do you have any objection to my calculation of the range based on the rulings?
No, Your Honor.
All right, so the advisory guidelines are now scored at 5 to 23 months. Mr. Parks, go ahead with anything you want to say in your comments.
Thank you, Your Honor. Your Honor, I think what's important here is what's happened since the incident occurred. Mr. Goddard is a completely different person than who showed up into my office saying that he was being charged with these crimes. Mr. Goddard is, since being sent to the jail, is now a temporary trustee. Depending on how today goes, I would request that the court either grant him the ability to remain a trustee if he is going to do some more time. And the alternative, Your Honor, what we have here is somebody who deeply loves his wife, believed that he could contact her after the court revoked his bond. Didn't seek my advice on that, but sought the jailhouse lawyers that everybody seems to have. And in those videos, Your Honor, that you heard, in no way, shape, or form is he threatening her. Is he telling her that, you know, if you don't do this, bad things are going to happen to you? He's a husband trying to reconnect with his wife. They've been married for 10 years now, going through a few rough patches throughout those 10 years. He clearly wants to still have a relationship with his wife. What the court should also take into consideration is the victim has been not involved in this case whatsoever. She didn't show up for prelim. She didn't show up, hasn't shown up today, has written no victim impact statement. In fact, the person here on behalf of her is her mother, but she's here for my client. She supports my client in this situation, Your Honor. She is like a mother to him. He's already lost two mothers.
She's the one sitting directly behind him. She's shaking her head right now, indicating negative.
Well, that was the information I had going in today, Your Honor. So Mr. Goddard is still attending church with the guys in the jail on Sundays. He's praying more than I've ever seen him pray before. Me and him have prayed together. He's doing everything that he can possibly do to make himself a better person. Your Honor, he's jumped through all the hoops that he's had to while in jail at this point, to the point that they're making him a trustee. And I can't speak for more than what I've seen in the change in Mr. Goddard. He loves his wife. He wishes that they could fix things. I'm not sure, what the future looks for them, but I can tell you this is not the same man that was here in the courtroom almost a year ago at this point, Your Honor. The guidelines did change to 5 to 23, pending any appeals or anything, Your Honor. It is up to the court to determine whether or not he's prison bound or whether he's going to do some county time. Your Honor, I would subject to you, he's already done 154 days as of today. I believe when we were here last time, the court said that he was going to do at least 6 months on record. So he's already done more than that. He's got good time from being in the jail so far. I think his stint on probation that he should get should certainly alleviate any other issues that the court would have for Mr. Goddard. And I would just ask that you sentence him to time served at this point and let him do his probation that he's scheduled for 2 years as recommended in the pre-sentence investigation report, Your Honor.
All right, thank you, Mr. Parks. Mr. Goddard, is there anything you don't have to make a statement today? If you don't, I don't hold it against you, but you're welcome to make a statement. Is there anything you want to tell me, sir?
Made some mistakes in the past, Your Honor. I was angry. I had some issues going on. I've dug deep. I found what my issues were myself. And I was not honoring my wife. I didn't cherish her like I should have. And I realized where I've gone wrong. I plead for your mercy. Thank you.
Thank you, sir. Mr. Wirgo, any recommendations from the people?
Your Honor, a felon took a 30-30, put one in the breech in battery, pulled a hammer back, pointed it at his wife, grabs a gasoline can, brings it in, threatens to light her on fire, beats her, and can't really think of anything else that makes him a more dangerous human being. He received a substantial benefit of the plea bargain. He's not facing the consecutives on the felony firearm. I think that he at least deserves the full 23. Your Honor, I think that there's even room here for the court to exceed. Definitely think he deserves the maximum. Thank you.
Thank you, Mr. Goddard. If you please stand for the court sentence. Goddard is 56 years of age. He has 1 prior felony that disqualifies him from having a firearm. It's got 9 prior misdemeanors. In this case, he's pled to felon in possession of a firearm and a misdemeanor domestic violence. The advisory guidelines are 5 to 23 months. In this case, I have to look at the circumstances of the offense and the offender. The prior record is not doesn't really display a history of assaultive behavior. So that goes toward mitigation. And then I also look at the circumstances of the offense. He's convicted of being a felon in possession of a firearm. So if he's out, say, hunting or target practicing in a law-abiding way, but for the illegal possession of the firearm, he would still be convicted of the same crime. I mean, the guidelines would be different to be sure, but you have to take into account the seriousness of this offense. This is not just sort of a vanilla, it's a felony for you to possess a gun. What you did with that gun while you possessed it is very, very troubling. You know, with a round chambered, pointing it at somebody, threatening them harm, threatening to burn them alive, beating them. This is a very troubling incident, and I understand the defense disputes, you know, some of the ways that's been characterized, but that's the information we have. That was the report that's made. You know, I think that's a terrible situation. That's not just cherishing your wife. That's, you know, putting fear into her, and it's terrorizing somebody. So, you know, if I just focus on that, you know, I'd be agreeing with the prosecutor at top end or even beyond, given the circumstances here, taking full credit and full account of some of the mitigation in that there's no prior assaultive crime. I think on the whole, the sentence will be as follows. I already issued the contempt sentence. There's state costs in this case of $118, crime victims assessment of $130, and court costs of $350. On the domestic violence charge, I'll order he serve 93 days in jail with credit for 93 days previously served. And as to the charge of felon in possession, Mr. Goddard, I'm going to commit you to the Michigan Department of Corrections for a term of not less than 18 months, nor more than 5 years, and give you credit for 154 days previously served. That's a sentence within the advisory guidelines, and it's not at the top end. I believe that it's proportionate to the circumstances of the seriousness of this offense, and the offender is outlined here today on the record. Mr. Goddard, if you wish, you can file an appeal to the Court of Appeals to challenge the conviction of the sentence for both. You can ask for an attorney if you want. If you want an appointed attorney, you'd have to ask for it in 6 months of today's date. We're going to ask you to initial one copy of this, a copy of your appeal rights. So we have a record we gave it to you. And the other one is for you to fill out if you wish to take an appeal.
The judge made the final call. Lawrence Goddard is heading to prison for up to 5 years. But here's the question. Given the terrifying nature of the threats, was that sentence enough? Comment below. Team prosecution or team defense? Should a changed man get a second chance? Or was this pure manipulation? If this case got you thinking, hit like. Share this with anyone who loves real-life courtroom drama.